The market capitalization of the coin is used to summarize all that is taught in this video. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news, as well as other cryptocurrency news in general. Now have a look at this Ripple litigation that seeks to clarify the validity of XRP by filing a Form C lawsuit with the NCC. On the other hand, before we go any further, there is a brand new cryptocurrency airdrop that is currently taking place on Telegram and is set to start at any moment. I would ask that you make sure that you take part in this airdrop. Within the video's description is where you will find the link. Make sure you don't miss out on this opportunity. In the meantime, let's proceed with our video. Following the submission of Form C to the Federal Circuit United States Court of Appeals, Ripple has initiated a cross-appeal in the ongoing litigation it is engaged in with the United States of America, which is the most prominent securities regulatory authority in the world. It is the intention of this post to provide an explanation as to why XRP is not considered a security and why the majority of the cryptocurrency market believes that it is necessary for the future. There are 4 significant cross-appeal issues that are brought to light by Ripple. The cross-appeal filed by Ripple raises 4 significant legal problems that are relevant to securities law. Within the context of the 1933 Securities Act, the first contemporary case raises the question of whether or not a non-constructive contract must be considered an investment contract. According to Ripple, certain transactions should not be considered securities if there is not a direct sale to the customer. As a result, the Securities and Exchange Commission is unable to regulate XRP because of this belief. In addition, the Howey test analysis of XRP sales is yet another significant factor that Ripple took into consideration when submitting its proposal. It has been stated by Ripple that the components of the Howey test, which is used to determine whether or not an investment contract exists, are not identical to XRP transactions. One component of this test is intended to generate revenue from the buyer component, which Ripple contends is not a feature of XRP or any other cryptocurrency. Ripple has requested that the Court of Appeals conduct a review in order to facilitate the implementation of the District Court's interpretation of the implant from the very beginning. In the midst of regulatory uncertainty, Ripple asserts that it has received fair notice. The fair notice argument is developed by Ripple, which provides support for the premise that the Securities and Exchange Commission (SEC) still needs to adopt specific guidelines for the sale of digital assets. One of the most important aspects of Ripple's argument has been that he has made a sufficient amount of ignorance regarding whether or not the sale of XRP would be unlawful according to securities regulations. Ripple is seeking to demonstrate that the SEC did not offer a foundation for addressing XRP sales as securities by extending the problem of regulatory uncertainty. This is being done in an effort to strengthen their position. It is possible that this method will have an effect on the management of other cryptocurrencies by setting trends in the associated industry. Using Form C, the blockchain startup Ripple, which has its headquarters in California, has submitted its anticipated cross-appeal, which outlines concerns to particular matters that were addressed in a recent court decision. Several significant aspects of a protracted legal battle involving Ripple's digital asset are addressed in this document, which was submitted not long after the Securities and Exchange Commission (SEC) requested an extension for the filing of its main brief. The case between Ripple and the SEC, which has been going on for almost 4 years, has taken a new turn. While the Securities and Exchange Commission (SEC) initially submitted its own Form CU on October 18th, arguing the portion of the court's order that indicated Ripple's programmed XRP sales on cryptocurrency exchanges were not intended to be considered securities. The purpose of Ripple's counter-appeal is to examine all of the significant decisions that were made on this matter. As part of the appeal that was only recently submitted, Ripple is requesting that the court provide assistance in defining what the Securities Act of 1933 considers to be an investment contract. Justification provided by Ripple suggests that the word should be utilized in circumstances where a contract provides the buyer with the opportunity to profit from the activity of the seller. This would be done in order to classify other cryptocurrencies in accordance with federal legislation. The cryptocurrency company Ripple contends that a particular definition of this phrase is required, as it may have implications for subsequent crypto cases. The previous decision of the court, which stated that the conditions of the Howey test were satisfied by the sales of XRP. In addition, the standard that is utilized to determine what constitutes a security is being challenged in Ripple's ongoing appeal. Because of this decision, Ripple was given a fine of $125 million for allegedly breaking federal securities laws by neglecting to register XRP sales to institutional investors. The violation was alleged to have occurred. Ripple asserts that these sales did not meet the criteria of the Howey test and demands that these transactions be re-examined due to this concern. In Ripple's third point of appeal, which focuses on disparities that have made compliance difficult, the guidance that the Communications Commission (CC) has provided about cryptocurrency regulation is examined. As a result of the fact that the SEC's regulatory guidelines were not sufficiently specific, the defense contends that it was unreasonable to expect conformity to rules that had ambiguous criteria. This assertion is supported by the defense's allegation that it was provided with fair notice. Because of the lack of clarity in the rules, any fines or punishments that are applied are unfair. During the later portion of the appeal, the company's primary attention is on the order issued by the court, which is an attempt to prevent Ripple from violating securities regulations in the future sales. In light of the fact that the conditions of the injunction are still not entirely clear, Ripple has requested that the court clarify the obligations that are outlined in Rule 65 of the Federal Rules of Civil Procedure. This rule outlines the compliance expectations that are expected of firms who are subject to such decrees. Ripple has made progress in its continuing legal struggle with the SEC by submitting a Form C cross-appeal. By taking this approach, Ripple hopes to make it abundantly obvious that XRP is not a securities. It is anticipated that the Court of Appeals will review the records that are now available without allowing any new evidence to be presented. Mr. John Deaton, a lawyer who supports Ripple, has confirmed that the sale of XRP on exchanges such as Coinbase is well within the bounds of the law. For the purpose of the cross-appeal, the CEO of Ripple provides a description. Following the submission of Form C, Stuart Alderati, who serves as the chief legal officer of Ripple, provided some insights into the primary issues that were brought up in this cross-appeal. According to Alderati, the action not only demonstrates that XRP is not a security, but it also goes beyond that. He emphasized that the Securities and Exchange Commission has not contested the decision of the court to designate XRP and Bitcoin as non-security assets. This Form C submission was remarkable due to the fact that it was made just a few hours after the SEC requested an extension to submit its major summary until January 2025. It has been reported by the Bit Journal that the case is currently being heard at the appeals court, where the judge will examine the current recorded evidence. According to Ripple's Chloe, the Securities and Exchange Commission would not be permitted to present new evidence or request further documents. The level of drama that has been present in prior cases will not be present in this one, Alderati stated. There were reports that Ripple's cross-appeal file was one day late because it addressed four main concerns. These concerns were addressed in the submission. Since the beginning of the action against Ripple in December 2020, the CSC has constantly arranged for extensions of time and has consistently submitted papers at the very last minute. Morgan stated that the maximum amount of time was available to complete the legal process. Morgan continued by saying, reports indicate that John Deaton, a Republican candidate and legal advisor to Ripple, has expressed his desire to become a member of the CVs as a legal representative for XRP holders. Ripple is involved in litigation. This takes place when Ripple and the United States Securities and Exchange Commission are still engaged in a legal dispute. New discussions are being sparked in the Bitcoin field by those who are participating in these regulatory activities. In a tweet that was sent out on October 24, 2024, journalist Eleanor Terrett disclosed that John Deaton had submitted an application to participate as an amicus lawyer in the appeal that was filed by the Second Circuit. In response to Terrett's tweet, John Deaton made the following comment: "I don't walk away from what I started doing in the Senate race." This illustrates that, in contrast to when he first began his career in politics, he continues to promote the interests of XRP holders. Additionally, John Deaton requested that the court keep its attention focused on the prior decision it had made about XRP. A judge announced that XRP is not a security in and of itself, and he also mentioned that it is legal to sell XRP through Coinbase. This was a remark that was made by the judge. As a consequence of this, there have been discussions on the legitimacy of the operations that the SEC is currently conducting against Ripple and other companies. Especially in light of the fact that the SEC has filed a lawsuit against Coinbase, the SEC's polarizing measures, known as the EKS, have come under scrutiny for the manner in which it controls cryptocurrencies. This is especially true with regard to the classification of various cryptocurrency assets and trading platforms. In his criticism of Gensler, the chair of the SEC, Deaton has been extremely caustic. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated in the field.